Donald Trump's lawyers argued to the United States Supreme Court earlier in the day that Donald Trump could steal nuclear secrets and sell them, that Donald Trump could launch a coup against the United States, that Donald Trump could accept bribes from foreign officials, and that Donald Trump could order the military to assassinate his political rivals. Donald Trump's lawyers were making that argument in the United States Supreme Court. Folks, I never thought, as someone living in the United States of America, that it would get to this. The very fact that those arguments are being made before the United States Supreme Court by a former president, by the Republican leader, this is a travesty. And don't take my word for it. Let me show you the key moments during the oral argument. I'm only going to break it down so you can just see the key moments from this oral argument where Donald Trump was arguing for absolute presidential immunity for his conduct in trying to overthrow the results of the 2020 election after losing in the lower courts. Trump lost in December before a federal court in Washington, D.C. Trump appealed it to the next level court, which is the D.C. Circuit Court of Appeals, a 3-0 decision against Donald Trump, including from a conservative judge ruling against Donald Trump. Trump then appealed that to the United States Supreme Court. Here, during the oral arguments, Justice Sotomayor asked Donald Trump's lawyer, is it plausible to you that creating a fraudulent electoral slate would constitute an official act that you could have immunity for? Play the clip.
Apply it to the allegations here. What is plausible about the president assisting in creating a fraudulent slate of electoral candidates? Assuming you accept the facts of the complaint on their face, is that plausible that that would be within his right to do?
Absolutely, Your Honor. We have the historical precedent we cite in the lower courts of President Grant sending federal troops to Louisiana and Mississippi in 1876 to make sure that the Republican electors got certified in those two cases, which delivered the election to Rutherford B. Hayes. The notion that it's completely implausible, I think, just can't be supported based on the face of this indictment or even
knowing that the slate is fake. Knowing that the slate is fake, that they weren't actually elected, that they weren't certified by the state. He knows all those things.
The indictment itself alleges, I dispute that characterization. The indictment affixes the word label to the so-called fraudulent electors. It affixes the word fraudulent, but that's a complete mischaracterization. On the face of the indictment, it appears that there was no deceit about who had emerged from the relevant state conventions, and this was being done as an alternative basis. But I want to...
Next up, Justice Kagan asks Donald Trump's lawyer, John Sauer, what about if a president orders the military to stage a coup? Is that an official act for which a president should receive immunity? Play the clip.
How about if a president orders the military to stage a coup?
I think that, as the Chief Justice pointed out earlier, where there is a whole series of, sort of guidelines against that, so to speak, like the UCMJ prohibits the military from following a plainly unlawful act. If one adopted Justice Alito's test, that would fall outside. Now, if one adopts, for example, the Fitzgerald test that we advanced, that may well be an official act, and he would have to be, as I'll say in response to all these kinds of hypotheticals, has to be impeached and convicted before he can be criminally prosecuted. But I emphasize to the court that—
Well, he's gone. Let's say this president who ordered the military to stage a coup. He's no longer president. He wasn't impeached. He couldn't be impeached. But he ordered the military to stage a coup, and you're saying that's an official act.
I think it would depend.
That's immune.
I think it would depend on the circumstances whether it was an official act. If it were an official act, again, he would have to be impeached.
Well, what does that mean, depend on the circumstances? He was the president. He is the commander-in-chief. He talks to his generals all the time, and he told the generals, I don't feel like leaving office. I want to stage a coup. Is that immune?
If it's an official act, there needs to be impeachment and conviction beforehand, because the framers viewed that kind of
If it's an official act, is it an official act?
If it's an official act, it's impeachment.
Is it an official act?
On the way you've described that hypothetical, it could well be. I just don't know. You'd have to, again, it's a fact-specific, context-specific determination.
That answer sounds to me as though it's like, yeah, under my test, it's an official act, but that sure sounds bad, doesn't it?
Well, it certainly sounds very bad, and that's why the framers have a whole series of structural checks that have successfully, for the last 234 years, prevented that very kind of extreme hypothetical. And
Next up, Justice Kagan says, well, what if a president sells nuclear secrets? You're Donald Trump's lawyer. Do you believe that selling nuclear secrets to a foreign adversary, do you get immunity for that? Is that the position that Donald Trump is taking right now before the United States Supreme Court? Play the clip.
If a president sells nuclear secrets to a foreign adversary, is that immune?
that sounds like, similar to the bribery example, likely not immune. Now, if it's structured as an official act, he would have to be impeached and convicted first before.
What does that mean if it's structured as an official act?
Well, I don't know in the hypothetical whether or not that would be an official act. You'd probably have to have more details to apply the Blazing Game analysis or even the Fitzgerald analysis that we've been talking about.
What about if a president decides to use the military to assassinate political rivals? Are you saying that that is allowed? Are you saying that presidents should get absolute presidential immunity for that? Is that Donald Trump's argument? Is that what you are asking us to hold today as the United States Supreme Court? Play the clip.
Can be alleged, but it has to be proven. Malum in se is a concept long viewed as appropriate in law, that there's some things that are so fundamentally evil that they have to be protected against. Now, I think, and your answer below, I'm going to give you a chance to say if you stay by it. If the president decides that his rival is a corrupt person and he orders the military or orders someone to assassinate him, is that within his official acts that for which he can get immunity?
It would depend on the hypothetical, but we can see that could well be an official act.
He could, and why? Because he's doing it for personal reasons. He's not doing it like President Obama is alleged to have done it, to protect the country from a terrorist. He's doing it for personal gain. And isn't that the nature of the allegations here? That he's not doing these acts in furtherance of an official responsibility. He's doing it for personal gain.
I agree with that characterization of the indictment, and that confirms immunity, because the characterization is that there's a series of official acts that were done for an unlawful.
No, because immunity says even if you did it for personal gain, we won't hold you responsible. How could that be?
That's an extremely strong doctrine in this court's case law in cases like Fitzgerald.
Well, we
Harlan,
go back
Johnson,
to
and so
Justice
forth.
Thomas's question.